from his studios in New York. It's time for Wake Up Call with Dan Tortora, where sports meets life. Here's your host, Dan Tortora.
Welcome back here to Wake Up Call with Dan Tortora on wakeupcalldt.com, your one-stop sports shop, and on mixlr.com/wakeupcalldt here inside of the Charney's Menswear and Tuxedo Studios. We're also live on Facebook.com/LiveNowDT, hanging out with you here every Monday through Friday from 9 a.m. to 11 a.m. Eastern Time, and continuing the conversation here in hour number 2 with the California law that was passed. As I said, state bill, it was Senate bill, pardon me. So Senate Bill 206, SB 206, on collegiate athletics, student-athlete compensation and representation. I'm going to read you the bill. It's not extremely long, but I do want to read this to you so that you have it. So just so we know, right? And I can actually post this for you as well so that you can see it. So Senate Bill number 206, chapter 383, an act to add section 674.562 and add and repeat section 67457 of the Education Code relating to collegiate athletics, approved by Governor September 30th, 2019, filed with Secretary of State September 30th, 2019. Legislative Council's Digest. So SB 206, Skinner, collegiate athletics, I'm just reading it. So if it sounds like crazy jargon, we're getting there. Student-athlete compensation and representation. Existing law known as the Student-Athlete Bill of Rights requires intercollegiate athletic programs at four-year private universities or campuses of the University of California or the California State University that receive, as an average, $10 million or more in annual revenue derived from media rights for intercollegiate athletics to comply with prescribed requirements relating to student-athlete rights. This bill would prohibit California post-secondary educational institutions, except community colleges, and every athletic association, conference, or other group or organization with authority over intercollegiate athletics from providing a prospective intercollegiate student-athlete with compensation in relation to the athlete's name, image, or likeness, or preventing a student participating in intercollegiate athletics from earning compensation as a result of the use of the student's name, image, or likeness, or obtaining professional representation relating to the student's participation in intercollegiate athletics. The bill also would prohibit an athletic association, conference, or other group or organization with authority over intercollegiate athletics from preventing a post-secondary educational institution other than a community college from participating in intercollegiate athletics as a result of the compensation of a student-athlete for the use of the student's name, image, or likeness. The bill would require professional representation obtained by student-athletes to be from persons licensed by the state. The bill would specify that athlete agents shall comply with federal law in their relationships with student-athletes. The bill would prohibit the revocation of a student scholarship as a result of earning compensation or obtaining legal representation as authorized under these provisions. The bill would prohibit a student-athlete from entering into a contract providing compensation to the athlete for the use of the athlete's name, image, or likeness if a provision of the contract is in conflict with a provision of the athlete's team contract. The bill would prohibit a team contract from preventing a student-athlete from using the athlete's name, image, or likeness for a commercial purpose when the athlete is not engaged in official team activities as specified. These provisions would become operative on January 1st, 2023. The bill would require the Chancellor of the California Community Colleges to convene a community college athlete name, image, and likeness working group composed of individuals appointed on or before July 1st, 2020, as specified. The bill would require the working group to review various athletic association bylaws and state and federal laws regarding a college athlete's use of the athlete's name, image, and likeness for compensation on or before July 1st, 2021, submit to the legislature and the California Community College Athletic Association a report containing its findings and policy recommendations in connection with this review. The people of the state of California do enact as follows. Section 1A, it is the intent of the legislature to monitor the National Collegiate Athletic Association, NCAA, working group created in May 2019 to examine issues relating to the use of a student's name, image, and likeness and revisit this issue to implement significant findings and recommendations of the NCAA working group in furtherance of the statutory changes proposed by this act. B. It is the intent of the legislature to continue to develop policies to ensure appropriate protections are in place to avoid exploitation of student athletes, colleges, and universities. C. The legislature finds and declares that California's community colleges are two-year institutions not governed by the National Collegiate Athletic Association. In knowledge of this, it is the intent of the legislature to create a community college athlete name, image, and likeness working group to study the California Community College Athletic Association's bylaws, state and federal laws, and National Athletic Association bylaws regarding a community college athlete's use of the athlete's name, image, and likeness for compensation, and report policy recommendations to the legislature and California Community College Athletic Association. Section 2. Section 67456 is added to the Educational Code to read. 67456A1. A post-secondary education institution shall not uphold any rule, requirement, standard, or other limitation that prevents a student of the institution participating in intercollegiate athletics from earning compensation as a result of the use of the student's name, image, and likeness. Earning compensation from the use of a student's name, image, or likeness should not affect the student's scholarship eligibility. 2. An athletic association, conference, or group or organization with authority over intercollegiate athletics, including but not limited to the National Collegiate Athletic Association, shall not provide a student of a post-secondary educational institution participating in intercollegiate, shall not prevent, a student of a post-secondary educational institution participating in intercollegiate athletics from earning compensation as a result of the student's name, image, or likeness. 3. An athletic association, conference, or other group or organization with authority over intercollegiate athletics, including but not limited to the National Collegiate Athletic Association, shall not prevent a post-secondary educational institution from participating in intercollegiate athletics as a result of the compensation of a student athlete for the use of the student's name, image, or likeness. 3B. A post-secondary education, this is B. A post-secondary education institution, athletic association, conference, or other group or organization with authority over intercollegiate athletics shall not provide a prospective student athlete with compensation in relation to the athlete's name, image, or likeness. C1. A post-secondary educational institution, athletic association, conference, or other group or organization with authority over intercollegiate athletics shall not prevent a California student participating in intercollegiate athletics from obtaining professional representation in relation to contracts or legal matters, including but not limited to representation provided by athlete agents or legal representation provided by attorneys. C2. Professional representation obtained by student athletes shall be from persons licensed by the state. Professional representation provided by athlete agents shall be by persons licensed pursuant to Chapter 2.5, commencing with Section 18895 of Division 8 of the Business and Professions Code. Legal representation of student athletes shall be by attorneys licensed pursuant to Article 1, commencing with Section 6000 of Chapter 4 of Division 3 of the Business and Professions Code. Obviously, those are codes that are already in place and articles and whatnot that we don't have here. C3, athlete agents representing student athletes shall comply with the Federal Sports Agent Responsibility and Trust Act established in Chapter 104, commencing with Section 7801 of Title 15 of the United States Code and their relationships to student athletes. Another thing you can look up. CD, a scholarship from the post-secondary educational institution in which a student is enrolled that provides the student with the cost of attendance as that institution is not compensation for purposes of this section, and a scholarship shall not be revoked as a result of earning compensation or obtaining legal representation pursuant to this section. That is D, So that's D by itself. E1, a student athlete shall not enter into a contract providing compensation to the athlete for use of the athlete's name, image, or likeness if a provision of the contract is in conflict with a provision of the athlete's team contract. E2, a student athlete who enters into a contract compensation to the athlete for the use of the athlete's name, image, or likeness shall disclose the contract to an official of the institution to be designated by the institution. E3, an institution asserting a conflict described in paragraph 1 shall disclose to the athlete or the athlete's legal representation the relevant contractual provisions that are in conflict. F. A team contract of a post-secondary educational student's athletic program should not prevent a student-athlete from using the athlete's name, image, or likeness for a commercial purpose when the athlete is not engaged in official team activities. It is the intent of the legislature that this prohibition shall apply only to contracts entered into, modified, or renewed on or after the enactment of this section. G. For purpose of this section, quote, post-secondary educational institution, end quote, means any campus of the University of California or the California State University, an independent institution of higher education as defined in section 66010, or a private post-secondary education institution as defined in section 94858. H. This section shall become operative on January 1st, 2023. And the final piece of the bill that we're all hearing about with the California Senate Bill 206 that is looking to have NCAA college athletes, student athletes be paid for their image, likeness, and name, as well as be able to hire agents, is Section 3. Section 67457 is added to the Education Code to read 67457A1. The Chancellor of the California Community Colleges shall convene a community college athlete name, image, and likeness working group. The working group shall include but not be limited to the following members. A. A Chancellor's Office representative. B. A California Community College Athletic Association representative. C. At least 2 community college student athletes. D. A community college athletic administrator. E. A community college athletic coach. F. A student senate for California community colleges representative. G. 1 member appointed by the Speaker of the Assembly. H. 1 member appointed by the Senate Rules Committee. 2. All appointments to the working group shall be completed on or before July 1st, 2020. B. The working group shall do both the following. 1. Review existing California Community College Athletic Association bylaws, state and federal laws, and National Athletic Association bylaws regarding a college athlete's use of the athlete's name, image, and likeness for compensation. 2. On or before July 1st, 2021, submit a report to the California Community College Athletic Association and the legislature pursuant to Section 9795 of the Government Code, containing its findings and policy recommendations in connection with its review pursuant to paragraph 1C. Pursuant to Section 10231.5 of the Government Code, this section is repealed on July 1st, 2025. So, that's a lot of jargon. That's a lot of verbiage, but that is the law. And I feel like it's important to read it to you, whether you're listening or watching, to know exactly what this law is, because what the media tells you that it is and, and what people might splice and move this over here and do this over there, it's important to know what the actual bill is saying, what this Senate Bill 206 is saying, what it means, what it does, what it can do, and the fact that community colleges are involved, because we're all focusing on the NCAA, but community colleges, which are not governed by the NCAA, are also involved in this bill. So that is the text of the California legislative. If you go to the California legislature, you get this. It's SB 206, Collegiate Athletics, Student Athlete Compensation and Representation. So I will put this up, and because I want everybody to be able to see this. So I'm going to add this. I'm going to see if it'll let me add the PDF file right now. And if it'll let me add the PDF file, then I will do exactly that. If not, then I will find a means to make sure that we get this to you so that you can see it, because you need to see it. You need to see this bill. And it's something that, I read through here this morning because I think it's important to understand all of the legal verbiage of it all and what it truly means and what we're looking for, and the fact that it really is the student athlete's name, image, and likeness, right? So it's their name, image, and likeness. You put their name on something, you put their image on something, you put their likeness on something like a video game, then that's what we're talking about. So their likeness, a Tommy. The way I read it, a Syracuse number 13 jersey, that's Tommy DeVito right now. So that's likeness. You put Tommy's image on a billboard. You put his name on something. You got to pay for that. And so this is where collegiate athletics may be moving to, at this current point, at least in California, by 2023. And they want collegiate athletics, including junior college, to be able to advance from this. And think about that. If the NCAA can do this, if institutions for collegiate athletics post-secondary education can do this, does that mean that Division I, Division II, and Division III athletes inside of the NCAA can get paid for their name, image, and likeness and junior college? So that means that Marywood University, where I couldn't get a scholarship to make money from the university, I could use my image, my name, and my likeness, and I could have made money as a basketball player there. If this bill is enacted and it's in place in Pennsylvania, I could make money going to Marywood and playing basketball. So Marywood doesn't have to shell out anything, right? I can get paid by somebody else outside of it. So, I mean, that changes Division III athletics where you don't get any money. And then, you look at Division II and you look at Division I, and then you look at the group of 5 conferences outside of the autonomous 5 that don't have full cost of attendance. So players are getting, they're getting something. They're getting a free education, plus they're getting a little bit more and a stipend and a little boost if they're in the Pac-12, the Big 12, the Big 10, the SEC, or the ACC. But you're not getting that in the American, and you're not getting that in, the Colonial Athletic Association and the MAC and so on and so forth. So, that brings up the conversation of what can we do as we move forward. So it is my hope and my desire that we can continue this conversation and, and keep this going to, if we're going to help out athletes, that we help out all athletes and really get that set up. So if you're watching here on Facebook Live, we're coming back here in 1 second here. And we're back on Facebook Live here hanging out with you, continuing the discussion on pay for play. So we appreciate you being here. We appreciate you listening on mixlr.com/wakeupcalldt. We're continuing the pay for play conversation. I just read the Senate bill to you. And for those of you listening and watching, I feel like it was important for me to read the bill so that we all have the information, right? Because, like I said, the media is going to take out pieces and this and that and the other, but to actually read the bill throughout is to get the full reality of what it is. So Senate Bill number 206, I'm going to post this as well so that you can get a look at it. So I'm going to post the bill after the show. So make sure that you're with us on Facebook at WakeUpCallDT, Twitter at CallDT, and Instagram at WakeUpCall_DT, so you can make sure that you get to read it. And outside of that, we look at the fact of where we're at right now. Senate Bill 206, beginning January 1st, 2023 in California. The bill has been passed there. California Governor Gavin Newsom put pen to paper on this. So the bill was passed. Now, the bill has been created or forthcoming. This is important to know as well in the conversation. What's going on with the bill elsewhere? Well, it's created or forthcoming in these states. Colorado, Senator Owen Hill, Republican, and Senator Jeff Bridges, a Democrat, will introduce a bill to be named bill, I should say, when their state's legislative session is active in 2020. No additional details have been provided in Colorado. Florida, there will be 2 bills on the table. The first from House of Representative Keon McGee, who's a Democrat. House Bill 251 has already been filed but not voted upon. It has an effective date of July 1st, 2020. The other from Representative Chip LaMarca, Republican, is not yet fully formed, but is also expected to have an effect date preceding the California law. So Florida's trying to get their law passed before 2023. They're trying to get this law done and on the table. They're going to have 2 bills on the table, one from a Democrat, one from a Republican for House bills, and they want them to be in effect before the California law takes effect. Illinois, Representative Chris Welch, a Democrat, has introduced House Bill 3904. The bill already has 9 co-sponsors. No additional details have been provided in Illinois. Kentucky, Senator Morgan McGarvey, a Democrat, has a bill in the works that is yet to be assigned or titled. No additional details have been provided. In Minnesota, Representative Nolan West, a Republican, plans to introduce his state's bill in 2020. No additional details have been provided. In Nevada, multiple politicians have gone on the record to say they will explore a similar bill to the one passed by California. In New York, Senator Kevin S. Parker, a Democrat, has introduced S6722, which is the most aggressive legislation of any state so far. In addition to allowing players to earn off their name, image, and likeness, the bill also requires schools to, quote, take 15% of revenue earned from athletics ticket sales and divide such revenue among student athletes, end quote, among other things. And you can read that bill in its entirety, and we're going to do that next week. Pennsylvania, Representatives Dan Miller, a Democrat, and Ed Gainey, a Democrat, are, quote, seeking a bipartisan group of legislatures to sign on to the bill before formally introducing it, end quote, in their state, and that's according to Time, and that's in the state of Pennsylvania. So if I was playing right now, I could be making some money. So I asked Senators Dan Miller and Ed Gainey, can this be retroactive? South Carolina, Senators Marlin Kimpson, Democrat, and Justin Bamberg, a Democrat, are building a bill that most specifically applies to revenue sports in their state. Football, men's and women's basketball. No additional details have been provided for South Carolina, so they're directing it more specifically to football, men's and women's basketball. In which means that Olympic sports and Title IX might be affected. Washington, Representative Drew Stocksbury, a Republican, has been on this for months. His proposal, House Bill 1084, has been going on since almost the beginning of 2019. From his own website, it says, quote, under the bill, it would be a violation of the Washington State Consumer Protection Act and state antitrust laws for the NCAA or any athletic conference like the Pac-12 conference to prohibit Washington student athletes from being paid for their services or to punish the team or school of an athlete who was paid, end quote. Maryland also been considering looking at something, and so we're looking at that. Connecticut State Senator Matt Lesser, Democrat, has been looking into the issue, quote, for several years. So there's that as well as we move forward. So then there's other states that are looking at it and other people that are allegedly thinking about it. But just to put that into perspective, not only has the law been passed in the Senate in California and should take effect January 1st, 2023, the state of Washington, South Carolina, Pennsylvania, New York, Nevada, Minnesota, Kentucky, Illinois, Florida, and Colorado are all on the trail of getting their bills done. And New York is the most aggressive one that wants 15% of athletic ticket sales to be divided up among student athletes. So the conversation continues. It gets more dicey, and it gets even, I mean, this is, and you can read the New York bill as well. As we just read the other bill here, we can read the New York bill that's there right now. And, you know, this bill was put out September 16th, 2016. And this bill will, you know, read all of that. We're going to go through that bill. I don't want to give you another bill to read today. We'll do that one at a different time. But, you know, just the reality of it all is that not only has something been signed in California, but now New York is not only looking for something to be signed, but New York is more aggressive. Pay the players for their name, image, and likeness and give them 15% of the sales. You know, that's really something to look at in the here and now. And the reality of it all is that collegiate athletics is on the verge of changing as we know it. There may no longer be the status of amateur anymore. There may be no more amateur in athletics anymore. And, you know, while we're at it, do we look here and even say that we can call this thing student athlete? You know, can we call them student athletes anymore? So, you know, there's a lot to be said about where we are right now in this world. And institutions have been making money hand over fist off their players. Take athletics out of Syracuse. Take athletics out of Kentucky. Take athletics out of North Carolina, Chapel Hill. Take them out of Florida, you know, for the Florida Gators or Florida State. And how much money do you lose? Take them out of Penn State, and how much money do you lose? You know, how many universities could survive without athletics is the question. So players needing to get something from the fact that the universities are existing because of this, it's I mean, like I said, it's multi-layered, right? If the universities didn't have athletic programs, then the student athletes would have nowhere to go. But if the student athletes didn't have the successes that they had, the university probably wouldn't exist right now. So, there's that conversation of, what does the university have in its power? What does the school have in its power? What does the NCAA? I mean, what does the university have? What does the student athlete have? What rights does the NCAA have? What rights does the state have? And it's just continuing to create the conversation in this domino effect of the reality that we are seeing a change to collegiate athletics. And we're going to continue to see a change to collegiate athletics over and over and over again if these laws continue to be passed. And that conversation and that reality of what we just are, what we're seeing here, that it's not just the state of California and the bill that I read today, SB 206. It's Florida, it's Colorado, it's Kentucky, it's Minnesota, it's Nevada, it's Pennsylvania, it's South Carolina, it's Washington. And for those of you where I'm at right now, it's the state of New York. And spoiler alert, the state of New York has a more aggressive thing that doesn't just want the student athletes to get money off their name, image, and likeness. It wants them to get a percentage of the ticket sales for the athletic events that go on at the university. So now you're going to say to the university, now you are going to pay something. A player gets paid for their name, image, and likeness. They go out there, they work with a Honda dealership. Okay, the university's not paying for that. But the university is going to pay a percentage of the ticket sales if that gets passed and that goes through. And that's going to affect Syracuse University if it happens here in the state of New York. So, we are on the cusp of something very interesting right now. And we are in the lifetime where we could see a drastic change to everything that we know about collegiate athletics. California started it. New York is trying to one better it. And Florida is not only trying to get their bill done, they're trying to push their bill through and make it effective before California. So California was the first to sign it. Florida wants to be the first one to enact the bill. And Republicans and Democrats are either bipartisan on this or, each working on their own bill or whatever it may be. But both parties, both major political parties in America are working on these bills right now. I can only imagine the conversations we're going to have in the coming weeks, coming months, coming years.